If you're the President of the United States, yes.
The President of the United States could have somebody else. The President of the United States has tons of trademarks. So you're saying that he doesn't have to submit himself? Where does it say in the Lanham Act that the President of the United States is exempt from the general rule that you cannot have a third party seeking an application on your behalf?
Did you catch that? A federal official, the director of the United States Patent and Trademark Office, just told Congress that the President of the United States is exempt from trademark law, the same law his office enforces every day for every American citizen, except, apparently, for the one sitting in the Oval Office. This is not a political debate. This is not a partisan talking point. This is a federal agency director under oath in front of Congress saying out loud that the rules don't apply to the president. And here's what makes it worse. Much worse. The trademark he filed, it was for the Board of Peace, an organization that, as of this hearing, does not legally exist. No formation documents, no legal status, no confirmed structure. 8 minutes into a presidential speech announcing it, a cyber squatter grabbed the domain name, and the Asto director decided that was enough of a national emergency to act. He filed the trademark application himself. He waived the $350 filing fee, and then his office approved that waiver the next day. Now, let's be precise about what's happening here. This is the man who runs the federal office that exists to process patents and trademarks impartially. He used that office to protect the intellectual property of a Trump initiative before Congress authorized it, before the organization legally existed, and before anyone publicly explained who actually owns it. This is what a conflict of interest looks like in real time. And the congressman from Maryland walked him right into it, document by document. Watch what happened when he started showing the director his own paperwork.
This was to protect the name Board of Peace as the entity gets booted up, to act as custodian in a very narrow capacity with a bona fide intent to use the name, and then its intent to use application.
Who has the bona fide intent to use it?
The USPTO.
The USPTO, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
But is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 U.S.C. Section 3 to advise the president on matters of national security.
So this is a matter of national security? Okay, let me ask you this. You've emphasized today, and rightfully so, the importance of people who are applying for patents or trademarks to pay a fee, because yours is a fee-paid office. How much does it cost for someone to seek a trademark? When you applied for that trademark for the Board of Peace, how much does that cost?
It's not an expensive fee, depending upon...
the website says $350, is that right?
Generally, yes.
It's not expensive, okay. And my, one of the able lawyers on my staff just passed me this, you filed a petition on January 21st, 26 to waive that fee for the Board of Peace. Then you granted that petition the very next day, which underscores the bizarre conflict of interest you're in, now acting both as a representative of the Board of Peace and also the trademark office that's going to pass upon the petition. But why did you seek a waiver for the $350 for the Board of Peace, and why did you grant it?
The waiver was sought under the particulars of the intent to use application as the custodial filer, and I did not grant my own application.
Well, your signature, as I'm reading it, you filed this on the 21st, and then you approved it on the 22nd.
Well, I would like to see the document to which you're referring.
Okay,
but,
we will get you those documents. Are you saying you would not have approved it had you seen it?
I'm saying I don't recall this particular situation. Okay, but I do believe it's in
your
my authority.
Signature, Okay, it was approved by Dan Vovanisi, but your signature is on the petition. And I guess,
Yes.
why did you request that waiver of the $350 payment for the Board of Peace?
Again, given that this is going to be an international organization, given the situation with the intent to use and the bona fide limited scope that we had, I made that petition just as I signed the application, and it was granted
Okay, and
by
then
someone
finally,
else.
you know that the Lanham Act forbids anyone from submitting an application unless they're the owner of the mark or the legal representative of the mark. So were you representing yourself as the owner of the mark or the legal representative when you filed the petition?
No, we are very clear. It's on a custodial basis. We are not the owner. It will be transferred to the entity once it's formed.
Okay, well, you're listed as the owner on the petition, both for the waiver and also the application. So, I mean, that's the way the Lanham Act works. In other words, if I'm asking for your advice, could I get another company to apply for a trademark for me? What's the answer to that?
If you're the President of the United States, yes.
The President of the United States could have somebody else. The President of the United States has tons of trademarks. So you're saying that he doesn't have to submit himself? Where does it say in the Lanham Act that the President of the United States is exempt from the general rule that you cannot have a third party seeking an application on your behalf?
I'm, again, directing you back to USC 35 USC Section 3, where it's the Undersecretary of Commerce and Director of the Patent Office shall advise the President on national and certain international intellectual property policy issues.
Those are matters of public policy. They're not questions of representing the president before the trademark office, which obviously creates a stark conflict of interest.
The gentleman's time has expired, but you may answer.
Sir, I was not representing the President of the United States in this regard. I was representing filing an application to address the cyber squatting issue under my authority under 35 USC.
I appreciate it. Thank you. I yield back, Mr. Chairman.
Thank the gentleman.
Let's go through exactly what just happened in that exchange. The congressman didn't come in swinging. He came in with documents, specific documents, dated documents with signatures on them. January 21st, the USPTO director files a petition to waive the $350 trademark fee for the Board of Peace. January 22nd, the very next day, that petition is approved, and his signature is on the original filing. Now he claims he didn't personally grant the approval, that it was signed off by someone named Dan Vovanisi. But he acknowledged he signed the petition. He acknowledged the waiver was granted, and when pressed, he couldn't recall the details. The head of the U.S. Patent Office couldn't recall approving a fee waiver for the president's unformed organization. That was the moment the whole thing fell apart. Because here's the legal problem he couldn't get around. The Lanham Act, the federal law governing trademarks, is explicit. You cannot file a trademark application unless you are the owner of the mark or the legal representative of the owner. The director admitted on camera the USPTO is not the owner. He admitted the Board of Peace has not been formally created. He admitted he filed as a custodian. But the application lists the USPTO as the owner. Those two things cannot both be true at the same time. And when the congressman asked the simple, direct question, can someone else file a trademark on your behalf? The answer the director gave was stunning. If you're the President of the United States, yes, he invented a presidential exemption. On the spot, in a congressional hearing, with no statute to back it up. The congressman asked him point blank, where in the Lanham Act does it say the president is exempt? The director pointed back to 35 USC Section 3, his advisory role to the president on intellectual property policy. But advising the president on policy is not the same as filing federal trademark applications on behalf of the president. That distinction matters enormously. One is a policy role, the other is practicing law before the office you run, which is precisely what the congressman called it, a stark conflict of interest. And the director had no clean answer for it. Here is where we stand. The director of the United States Patent and Trademark Office filed a trademark for a Trump initiative that has no confirmed legal status. he waived the standard fee. His signature is on the petition that received that waiver, approved the following day. He justified all of it by citing a statute about advising the president on policy, and then stated directly that the President of the United States is exempt from the standard rules of trademark law. No statute supports that claim. No precedent was cited. Just an assertion made under congressional questioning that the rules are different at the top. If that logic holds, then the federal office designed to protect intellectual property for every American citizen can also be used as a private legal service for the executive branch. That is the question Congress is now sitting with. And based on what we heard in this hearing, nobody in that room has a satisfying answer. If this is the kind of story that never trends but absolutely should, subscribe. We break down the hearings they don't put on the front page. Drop a comment. Do you think this was a legitimate use of federal authority, or was this the USPTO director acting as Trump's trademark attorney on the taxpayer's dime?